Number here is, looks like 49. Okay, fourth cause of action. All right, now, what this case was over was the reason they figured they're going to rip and tear on these people and get all the money is the Torture Victim Protection Act. And what we show here is that Congress never had the authority to enact this clunker, because basically what it does, it gives our federal courts jurisdiction for things that happened in foreign countries. All right? Which would be like giving the Republic of Mexico the authority to come up here and say, okay, you violated Mexican law, all right? Or rather, let's say you're a turista, you're down in Mexico, and they've got you down there and say, well, you know what? You violated Mexican law, you were in Arizona or North Carolina when you did it, but since under this act we have jurisdiction, we are going to try you in civil courts and we're going to take everything you own, which is what this Torture Victim Protection Act is. This particular situation was addressed in the district court in the Second Circuit, and they threw it out. But these maniacs in the Ninth Circuit decided that this is exactly what they were going to do, and as far as I know, they did it. Fifth cause of action, go to page 51, where we show that the Torture Victim Protection Act violates the ex post facto clause of the United States Constitution. Okay? Now, this is kind of tricky ground here because we're showing that this refers to criminal offenses, and for criminal offenses, it's ex post facto. In other words, if something is against the law today and Congress passes a law tomorrow,
Good morning, folks. This is the 17th of April, 2001, Anno Domini, at 2 a.m. in the morning. The deliberate limiting and prohibiting of public access by Charles Dolan has turned everything topsy-turvy. Things haven't got done, and what has got done has been in a very disorderly manner, and perhaps the quality of the task has suffered because of the pressure that public access producers are under because of Charles Dolan making us run around and force somebody in the community to sign his illegal contract, quote unquote, and illegal application, quote unquote, and to accept the un-Americanism in his public access kit, quote unquote. let's start with the, this is a fantastic cartoon. The Michael Brown Lawsuit Cookbook. It is a cookbook that tells you how to file a lawsuit and to go pro se. Isn't it terrific? Now this cartoon is my joy and my delight. What you see here is a pro se who has in hand the crooked judge holding same by the tie. The judge lets go of the gavel. It pops him on the head. And with his other hand, he has a crooked lawyer in tow. And then he has his foot on the U.S. attorney. And this is what pro ses must do. They must take the court situation in hand and they must bring in rein these crooked judges and these crooked lawyers and these crooked U.S. attorneys. This is a superb book. I've read about 50 pages of it. I can only spare 5 minutes a day to read it, but at least I do something on it. This is the Michael Brown's Lawsuit Cookbook. Here is another book Michael Brown sent me, and I wish I had time to read it to you. The Bill of Rights Restoration Act. Judges have ignored the Bill of Rights. Lawyers have ignored the Bill of Rights. When you go to court, you don't have any rights. Therefore, you don't have a court. And this little booklet tells about these things. And he speaks a great deal about the veterans and the veterans who put up this flag. Those 4 veterans there were and how 2 of them later died in the war for freedom. As Ben DeFont says, are you enjoying your freedom? Then thank a veteran. Well, sometimes what happened on Tuesday, editing day, April 10th? It was good. The equipment always works there. I think I did only 5 programs. I was middle of doing the 6th when Rude Goldberg came in. And at the sight of her, it was 1:15. I stopped the editing, packed up, took Acumen for a walk, and left. And I went to Bethpage. And at Bethpage, I have here on audio tape my first exercise of statutory rights to see the Cablevision books, records, and minutes, and the shareholder ledger. And that was denied. I made the demand of Charles Dolan's office. Charles Dolan, the chairman, who doesn't know when the annual meeting is. So I called up Charles Dolan, as you heard on audio tape, and I informed the office when the annual meeting is. It is June the 5th at 10 a.m. at Bethpage. At Woodbury, Diane Bennett and Amy Van Horn refused to see me, and so and they had put the 5 tapes that I submitted on April 3rd in the cabinet to be picked up. And so I put those April 3rd that had not been cable cast if you shake this microphone, I think that didn't even get the news at all. And so I took those 5 tapes of April 3rd and added to them the 5 tapes of last Tuesday, April 10th, stacked them together and put them back into and gave them to V. This you must say about V is that V should belong to the Canadian Mounted Police because she always gets her person. You ask V to do something and it gets done. She's terrific. And so there were letters there, stock letters from Bennett saying that they wouldn't cablecast the program until somebody had signed these odious and illegal applications. So the next stop, oh yes, and I also published this file. And I saw many people had signed the applications. There must have been about 50 of them in there. And I took down some names and addresses and telephone numbers. And I saw the least access file, and they don't give me the right. Diane Bennett and Amy do not give me the correct least access file. It should be the same as a public access file with the applications, so you can see the people's addresses and their telephone numbers. It takes a long time to call 411 and try to get the telephone numbers of these people. And most of, out of 10 for instance, you'll only get 2 who are really real. The rest are all phonies. The least access list is phony, like the shareholders list. Dolan in his toy army, his toy soldier army, as the Emperor Napoleon, keeps fake lists. And I have found this out. And it takes a long time to research this. One least access applicant I called, Glenn, said he could not buy lease access because Cablevision required a $1 million bond. Now this is abuse of lease access, and it's limiting and prohibiting leased access just the way Dolan limits and prohibits public access. And Glenn said that he could not find an insurance company who would sell him such a bond. So there's a lot of work to be done on there. Dolan has to be reported to the Federal Communications Commission for limiting and prohibiting public access and leased access. And then I asked to see Jeff Clark, and I asked Jeff Clark, what is the matter? That I cannot see the political sponsorship file that is over at Rainbow Sales, which sells cable TV time for Charles Dolan. And Jeff didn't know, or he put on an act that he did not know. And so I went over to Rainbow Sales and I made my, I think it's the 6th demand to see the political sponsorship file in the public inspection file. The FCC, as you know, mandates that a public inspection file be kept by every cable system, and that part of that file is the political sponsorship file. There's a short in this microphone. It's a very good microphone. I guess I'll have to get a new one, or I have to use my remote microphone. So I went over. It was 20 minutes to 5, around 4:30, and I went over and I asked Zorita that I was there again to see the political sponsorship file. And this time, instead of getting a dodge, the way I did with Mike Rowty. Now remember, this is April the 10th I'm talking about. Michael Rowty had come out and said that he had no idea what this is about. And I says, well, I'll tell you what it's about. The Federal Communications Commission mandates that every cable system keep a public inspection file. And part of that public inspection file is the political sponsorship file. And Mike Rowty was hopelessly at his wit's end, and he fled. He just turned around and ran. This time I went over and Zorita says, yes. I'll have you go see Josephine. And lo and behold, Zorita took me to a conference room. Josephine appeared with a cart on wheels, and here were about 12 volumes, great big fat files, big ones, 9 by 12, and inside them were about 12 manila folders. And I went through that file, and I found out and saw copies of checks of politicians who had paid Dolan for airtime, for cable TV time, cablecast time. And they were big checks. There was a check there for $102,000. There was another check there for $62,000. There was another check there for $50,000 and $42,000. Charles Dolan squeezes money out of everybody, out of you, the subscribers, out of the least access users, out of the shareholders. He never pays any dividends. And now out of the politicians. He just wrenches money out of everybody. And I saw checks for $10,000 and $9,000 and $8,000 and $7,000. And I told Josephine, who was very helpful about presenting the political sponsorship file, I told her that I would have to stop looking at the files at 5 o'clock because that's 5 p.m. business hour. That was terrific. What does this mean? That finally, on something, Charles Dolan obeyed the law. On something, he obeyed the law. He produced the political. I didn't bring my copy. Josephine wasn't sure that I could make it. I'm going to change over the mic or use the camera mic. Okay, I think I got the static out of it. And that was Tuesday. Then I didn't get home until about 6 o'clock, and I had traveled something like 97 miles. So Bennett and Van Horn were not going to cablecast the programs. They were illegally depriving me of my right to public access. And so it was necessary to play their game. And I got up the next morning, early in the morning I think, and I assigned the 6 editions, made sure that every edition had a cable system, and I made sure that every cable system had an edition. Excuse me, it's 2 a.m. Everything backed up, and I had to get up at 2 a.m. to make these reports to you in order to get them done this morning in time to edit them and hand them in. And then all of those tapes had to be labeled and dated, and they had to be put on the calendar. And so that big job was done. And early in the morning, around 7 o'clock, 7:30, I started calling people to see if they would sign these as local residents of Nassau County, Huntington, Babylon, and Islip, or Huntington, Islip, and Babylon, if they would sign this screwball so-called contract and application, all of which are illegal, and they will not stand up in court. Ed Galkey said that he couldn't because he's in Suffolk, but he knew several people in Nassau. And so we made an appointment to meet at 1 o'clock, and we would go over to Nassau and have one of his friends sign this. And then to back this all up, to be sure, I called Ehrlich, and he said that he would sign them around about 11 o'clock. I made an appointment with him. By then it was 9 o'clock, and then Carl Lancesera was in, and I called Carl, and we went over the application over the phone, and I told him how to fill it in, and he signed it. And I said I would be out at noon to pick it up, and then I called Ehrlich and said that Lance was going to sign it, and I called Galkey and said that Lance was going to sign it, and would they please stand by in the wings in case anything else happened. So at 11, Franklin was wrapping the tapes, and I put Acumen in the car, and we drove 40 miles or so out to Huntington Station, 1395 New York Avenue, and there we, Carl had signed them, and the nice young lady in Carl's office had given me a salad, a very good salad, with tomatoes and all kinds of greens, except money. And Adeline told me about the horrible thing that had happened to her, how the courts were taking away everything she had and going after her father's estate. That's the way they do. They find people with money, and then they charge this person with a phony charge and bring them to court and convict them, and to get the money. That's the civil RICO that goes on in all the courts all over the country. You've heard Michael Brown tell about it. So it isn't just something in the Eastern District of New York, it's all over the country. That's the way the state district attorney acts, and that's the way the United States attorney acts. They go after the money. It's a civil RICO. RICO stands for what? Racketeering, influence, crime, organization. Governments act as civil RICOs. Courts act as civil RICOs. municipal governments act as civil recalls with all the parking tickets and all those things. Anything to wring money out of the public, you the public. And so Adeline told me about it, and I took down her number, and I can't find her number. And I've called up Carl to get it so that I can talk to her, because I have some people to put her in touch with. And then Carl signed, Bennett and Van Horn are requiring Carl to sign for every special now that used to be submitted freely and played freely on the cable TV in the spirit of public access to inform you, the public, of what's going on in your neighborhood. And in the case of A Chat with Glendora, of the crooked things that are going on in your neighborhood and how you are being flinched and deceived. And so Carl signed a whole bunch of those. And then I went as fast as I could to Woodbury, and I took the 10 programs, and I handed in the 10 applications to go with them. I handed in the generic application, which keeps the program on, and there shouldn't be any such requirement, on Friday nights at 10 p.m. on Channel 71. And I handed in the 10 specials, 5 for April 3rd and the 5 for April 10th. Lori didn't show up and pick up her tapes because poor Lori is stretched out at both ends by the things she has to do to protect people from the gangsters in our government. So she forgot to pick up the tapes, and they're heavy. Tapes that I picked up from Brooklyn and Manhattan and Queens and Yonkers. So all day long, again, was ruined by Charles Dolan. It's probably the 600th day in my life that has been ruined by the Charles Dolan law-breaking, which I will not tolerate, which as an American I feel compelled to oppose and bring that man to justice. I think that man should be fined and put in jail. So, Franklin finished wrapping the tapes. I did all the chores, taking care of the cats and dogs and getting things ready for bed. And that was all day Wednesday, taken up by Charles Dolan. And then came Thursday. I got up early, 4:30 or 5 o'clock. With acumen, you can't do much else. And I did a few of the chores, but not all of them. And then I started telephoning around 7 or 8 o'clock to find a person who would sign the Yonkers odious contract and application. And I finally located Fran Finesse, another victim of civil recall in the courts. She bought a co-op in the Harlem. She was overcharged for it. And then the people in the co-op went after Fran because she had money and because she had possessions. And so the crooked people in the courts took Fran's co-op away from her, took her money away from her, took her pianos, took all of her videotape equipment, took all of her possessions away from her, another civil recall, and this is in the Manhattan court. And then, because Fran was valiant and stood up for her rights, the gangsters in the government tried to set her up and get a criminal charge against her, and they made up a fake criminal charge against her. And they do one of two things. They make up a criminal charge against you, or they make up a psychiatric claim against you, and they try to put you away. This is how vicious and how evil and how sinister the people who are now in government are. And I took Fran to lunch, and it cost $20, and that's a whole lot of money for me. But it was a delicious lunch at a diner on Broadway in Yonkers. Fran signed the odious contract and applications, and we gave her a copy and a copy of the book, the kit. And then at 3:30 or 3 o'clock or so, I hastened to Yonkers to hand these in to Brenda Cherry because they have a fake deadline of April the 15th. Now you got to be a special kind of stupid to set a deadline on Sunday. You got to be another extra kind of a special stupid, which Cablevision is, to make the deadline on Easter. But that's what they did. So I rushed these up to Yonkers to get them in. And Brenda Cherry had left for the day. And here it was mid-afternoon. And she wouldn't be back until Tuesday. So I called and asked for Bernie Galley, and Bernie Galley's never in. And then I asked for Emily Spaulding, and Emily Spaulding came up, even though it isn't her job. Her job is to negotiate franchises with municipalities, such as TCI negotiated with 20 municipalities in Westchester, Greenburgh, Rye, White Plains, Eastchester, Bronxville, Scarsdale, and gypped us out of system-wide public access. And to this day, our freedom of speech has been illegally infringed upon since 1996. So Emily Spaulding, I asked her, when are you going to give us back system-wide public access, that you're in the medieval ages, that the people in those 20 municipalities are living in the dark ages. They don't have system-wide public access. They have no public forum system-wide. Oh, well, we're working on it. Working on it. It should have been done years ago. And by the way, John Malone, the thief of public access, whose financial empire has been crushed here in the United States, and he deserved it, is now looking overseas to try to build other cable TV financial empires and see if he can't get back his status. But he has been stepped on, and that is exactly what he deserves. Because he traded TCI for AT&T stock, and AT&T stock is... Now we will have to buy AT&T stock. You see, originally it was Continental who limited and prohibited and broke the law, first come, first served, and infringed upon free speech. Saturday. And they got sued. In the meantime, Continental was gobbled up by U.S. West, and they changed it to Media One. And McCormick and Lillis continued to break the law, and they got gobbled up. They're both out of jobs. They got gobbled up by Quest, and Media One got gobbled up by AT&T. So I really should sell the Quest stock, and I should, the one share I think it is, and buy AT&T. Part of Franklin's inheritance was some AT&T stock. I've forgotten how many shares. And it wasn't doing anything, it wasn't paying anything, and it wasn't worth the bother, and so we sold it about 20, 25, 30 years ago. So Emily Spaulding did the paperwork, received the contracts and applications that Fran Finesse had signed, and there was a man there named Roger O. He doesn't write his last name legibly, and he's from Peekskill, and I asked him to sign the application for Peekskill, and I don't have a great deal of confidence in him. I could take care of him for several places, Harrison and White Plains and Nassau and maybe Hauppauge. But I don't have a great deal of confidence that he'll take care of Peekskill, and he said he could also take care of Yorktown for me. All of them are signed except 3, Yorktown, Peekskill, and Harrison. And you understand, they are intimidating us by saying that if they aren't signed, they will not cablecast. Now how's that for a limitation of a public forum and free speech, and violation of Congress, and violation of the state legislature, and violation of the municipal franchises? So, I've forgotten what else happened on Thursday. But in the meantime, 11 legal papers had piled up. Papers that have to be worked on every day to be written, to be expressed, and to be distributed. So Friday, just a little bit of time to do the chores, and on the telephone again early in the morning, and I called Benny DeFonce, who has sponsored, that's a bad word, who has been the local contact for a chat with Glendora and Harrison and Port Chester for years. And I said that Cablevision this year wanted things signed. And so I went over to his house at 9 o'clock and found out from him what to say about the veterans. I want to say to all of you veterans, go to your local VA office. There's one in White Plains, there's one in the Bronx, and one in everywhere, in Manhattan and Long Island. Go to your local VA office and sign up for your veterans benefits and get a card. And they'll take care of your eyeglasses, and Benny says they take care of your shoes, and they take care of your medical care. And there's other veteran benefits like a flag, or you can be buried in the Veterans Cemetery in Calverton, Long Island. There's widow benefits and widower benefits. So veterans, please go to your local VA office and sign up and get a card. And Benny keeps saying, enjoying your freedom? Then thank a veteran, such as the Iwo Jima. And so Benny, he had on his dining room, great big dining room table, he has a nice house. There's a great big china basket. It's this long, it's this wide, and the handle comes up like that, and it's just filled 3/4 with candy, Easter candy. So Benny signed the contract and the applications. That's Benny DeFonce and Harrison. And then I had to go to Connecticut, to Norwalk, and hand in a chat with Glendora that was made on Tuesday, and pick up 6 a chat with Glendora programs that had been cablecast. And John Sherwood told me that he talked to Bill Budrow and that everything was all set as far as the application and the contract. And then John Sherwood and I sat down and we talked, and it was fun. It was nice. I like John Sherwood. And he told me about his wife's being a school principal. And did I ever tell you the joke about that Franklin, when he was covering the PTA, when he was covering the school board in Springfield, Massachusetts as a reporter for the Springfield Union, the superintendent told his joke that a woman didn't feel very well and she went to the doctor. And the doctor said, well, there's nothing wrong with you. He says, you're just expecting a child. And the woman began to cry inconsolably. And the doctor said, but it isn't that bad. She says, it isn't that. It's the thought of all of those PTA meetings again. And so John and I talked for a long time, and I enjoyed it. And Acumen had taken off. I tell you, he's a chore, that doggy. He's awful cute. Acumen, did you want to come in? Here he comes. You awful cute dog. But you bad dog. And I'd taken Rusty, so that was good. Rusty loves to ride with me. And we went to Connecticut, and we came back, and I went to the White Plains Post Office. The in-mail is horrendous. Stacks and stacks of in-mail, which makes all these legal papers. I hate in-mail. And I mailed a chat with Glendora, and it cost about $19. And I came home Friday afternoon. Oh, and I went to Bronxville. And because the appearance ticket they gave me is really illegal, and one of the legal papers I wrote was saying that the appearance ticket had to be dismissed because it was hopelessly and fatally defective. It said running at large. It didn't say what was running at large. And this was a violation of my due process. And so I wrote out a motion, a notice of motion, to dismiss and an affirmation in support. And then I took it to Bronxville. But those lazy people, before noon, were shut up tight. Friday was not a holiday, by any stretch of the imagination. But these loafers have to make a fake holiday and go off and loaf at the taxpayer's expense. So then I came home, and by the way, we had beautiful weather that day. The weather that we're supposed to have in spring. And then I had to recuperate. But first of all, I got a real meal, because with all of this running around, keeping up with the illegal things that cable does, illegalities, and keeping up with the law breaking of Charles Dolan, there was no time to have a real meal. And a real meal is like vegetarian hamburger, or vegetarian fried chick, or vegetarian cold cuts, or vegetarian hot dogs, or whatever, and potato or rice or some kind of a starch like that, and a green vegetable or an orange vegetable or something. But that's a real meal, and there was no time to have one, along with a salad and fruit juice and nuts and a fresh fruit. So that's the first thing I did, made sure that Franklin and Glendora had a real meal. And then I sat down at the desk, and that's what you call solar energy, S-O-U-L-A-R energy. And prayed and meditated. And then I got up enough strength to do a legal paper. Now, which one was it? Well, it's one of the ones in this pile. And that was Friday. Saturday, I declared I would not go out. I should stay in every day and write these legal papers until they're done. And so Saturday, I think I did five legal papers. And I'm going to go through those with you. Sunday was Easter, and that was a rush around doing the chores and getting the laundry done and grocery shopping for the dogs and cats. And Franklin is very good now. He gets up by himself, he gets dressed by himself, and he looked very, very nice in his red and black plaid vest and his black Sunday church suit. And we went to church, and Easter was jubilant. Patty came over to the church to fetch us because her finger was injured. Then we went over to Pat, and I went over and I bandaged her finger and got disinfectant on it. And we talked. I didn't get home until about 2 o'clock. That's too late. But I did several legal papers. Monday, I tried to make it an in day, and I got the meditating up to date and the praying up to date. There's 47 details and 11 legal papers. Reading the Brown Book, which is so interesting. A memorandum of law to my New Mexico judge. Callaghy is doing his filthy, underhanded, dirty, liar for hire work for Charles Dolan, saying in the Delaware court Glendora's informer papyrus should not be granted because she files frivolous litigation. Well, what is frivolous is Callaghy's papers and Dolan's hiding and the orders of the judges that Dolan buys. That's what's frivolous. And I have to sue Brooklyn, Domingo Martin, and Oneida Coward, Mayor. I have to sue those people because they are limiting and prohibiting public access. Doris Sassauer disconnected the telephone answering machine for 949-9495, a dirty thing to do. And I had to write and tell her, but also to thank her for having the telephone there for so many years. And Dolan shareholder, I'm writing the number 18 memorandum to the Delaware court on him, and doing the public file, the things that I just reported to you on least access, public access, and the political sponsorship file. And I did a lot of work on the refiles, the lawsuits that were handed in and that were not adjudicated on their merits. And there's about 40 people to sue there, mostly judges who betray America, betray you, the public, and betray your rights. So, and then there's quite a few errands. So Monday, I wrote on the legal papers until 9 o'clock, and at 9 o'clock I took the notice of motion to dismiss the appearance ticket for Wednesday night over to the Bronxville court clerk, and it's stamped received. and came back, worked on legal papers again, and yesterday I did 1, 2, 3, 4, 5, 6 legal papers. 1, 2, 3, 4 did not get done. I went to sleep on time, 9 o'clock, but awake at 1:30 because all of this work of making these reports to you had to be done. And now it's 5 minutes to 3 a.m. Proxy statement for Quest. You always vote against what the board recommends, and you always vote against the list of directors. I'm glad that Saul Trujillo is out of there. He's a terrible person. This is the note to Dr. Brad R. Sachs to please write an essay on what Glendora is doing and on its significance and on your approval of same. Brad Sachs is going to take care of the public access and pro se museum and keep it safe in storage. This is the first time we've had any good in-mail for a long time. This is an organization called As a Matter of Justice, and it's this is a petition signed. Franklin signed one and Glendora signed one, and I do not know how they heard of us. But it's a petition in the United States House Judiciary Committee petition for redress of grievances, and comes now Glendora and presents to this honorable body this petition for redress of grievances as guaranteed by the First Amendment to the Constitution of the United States. The facts that support this petition are as follows. The petitioner was a litigant in the Second Federal Circuit. The First Amendment to the U.S. Constitution guarantees the petitioner a right to petition his government. The Fifth Amendment to the U.S. Constitution guarantees the petitioner a right to due process, and so forth. The Seventh Amendment to the U.S. Constitution guarantees the petitioner a right to a jury trial. And this petition is against the Second Circuit and to the chicanery that goes on in the federal courts. By the way, we did get a letter from Orrin Hatch, and so Franklin made 9 copies of this petition and left a blank space for all these people to sign, and we sent it to Sassauer, we sent it to Brown, we sent it to Galgano, Crescenzi, I believe. Franklin made out the envelopes. So, and they're going to have a rally against the federal courts on May 6th, and I would like to go. Do you think that I can arrange that? I think this is terrific. It's called A Matter of Justice. Post Office Box 6963, Washington, D.C. We demand attorney and judicial accountability. We demand our constitutional rights. Isn't that great? I wonder who told them about us. But they certainly got the right people on their side for this. Here again, I want to point out to you the Michael Brown lawsuit cookbook, how to file your own lawsuit. And I love this cartoon. See the pro se in the yellow shirt? He's had it with his crooked judge. He's got the judge by the tie, and the judge loses the gavel, and it pops on the judge's head, and he's got the lawyer by the hair and off of the floor, and then he's got his foot on the U.S. attorney. And that's just what pro se's have to do with these crooked people. The system is okay. It's the gangsters who are in it right now that we have to get rid of. And also Michael Brown's the Bill of Rights Restoration Act handbook. I have to read that and tell you about it. Alrighty. What else do we have here for legal papers? We have Glendora's memorandum to her United States District Judge in New Mexico regarding the law breaking of defendants Dolan through Satterley. And that has gone out, and that tells pretty much what I've just told you about the time it has taken to get signers to this illegal contract and application. Here is a huge paper. This was the order to show cause. First of all, it's a motion to add Charles F. Dolan to the lawsuit that's in New Mexico, and to add James L. Dolan, Robert S. Lemley, Mark Budill, Charles A. Former, Maurice Cunningham, Brian McNeil, Diane Bennett, Amy Van Horn, Christine Savarino. Cablevision Systems Corporation, Robert Callaghy, Satterley, Stevens, Burke, and Burke, to this lawsuit for limiting and prohibiting public access, for denying first come, first serve, for robbing free speech. And that was a motion to add them as defendants, and then an order to show cause for a permanent injunction on these lawbreakers for what they're doing to public access and public forum. So veterans, you should sign up at your local VA office and get a card and get the benefits that veterans deserve. They deserve a whole lot more benefits than they're getting. We owe everything to veterans. As Benny DeFont says, are you enjoying your freedom? Then you thank a veteran. I want a copy of Benny DeFont's speech on Memorial Day, for the Memorial Day parade. These are the people that Americans for Legal Reform want to know about. That's funny how that turns blue. Let me go turn on the lamp and see if we can get it so you can read it. Do you have any information on any of these people? I get in touch with Americans for Legal Reform. Charles Former is Charles Dolan's court jester. You know, the old court jesters with the pointed hats and the bell, and red, green, and green, red. And the shoes, the slippers with the pointed toes and the bells. The number for our legal reform, Americans for Legal Reform, is 631-421-6390. 631-421-6390. 631-421-6390. I'm disappointed with that JVC camera. It went into lock, so-called safety lock, and it won't do a thing. And you can't get it out, and I asked Rob Kornfeld if he could get it out. I asked Patrick Galino if he could get it out. It won't move, it won't do a thing. It just comes up on the screen through the viewfinder in safety lock. So yesterday I took it back to PC Richards. And I'm just not impressed with that JVC. It just is not the camera that my Canon is, this one right here. I'm not impressed with it at all. This was a big legal paper that I don't have time to read you, and that's too bad. That's limiting and prohibiting public access. You should hear about all the crooked things that these defendants have done. This is saying that Cablevision is a civil RICO. A civil RICO always has a motive of money, and so that's what Cablevision has. A civil RICO always engages in extortion. That's what Cablevision does with your rates, okay, increasing your rates. And extortion is what they're doing with the public access programmers. If you don't have somebody in the community sign this application and this contract, your program's not going to be cablecast. That's extortion. So this is a very good paper against that foolish Michael Goldberger, who writes these silly papers, and all of his exhibits are in my favor, and he's an assistant U.S. attorney, and this Judge Raji is a former assistant U.S. attorney. So you can see what's going to happen to that, I think, or probably guess. As I say, we are writing the Omnibus 2 lawsuit combined with the refiles, the lawsuits that never got their day in court. Okay, here's the new Cablevision Rainbow stock certificate. And it's 6 shares instead of 4. Let me go see what Acumen wants. Hello.
Hi, Glennie.
It's 3:10 a.m. April 17th, and Franklin just got up with his walker. Cablevision trying to rob Glendora over 4 shares of stock. See, they're trying to get rid of Glendora as a shareholder and take away my right to see the books, records, and minutes, which I've asked for 91 times, and for which Dolan has broken the law at least 81 times. But that has come to nothing. There's a fatal defect in that they asked for all of Glendora's shares for Cable Systems Corporation Holdings Incorporated, CSC, Cablevision System Corporation. Now there's a Cablevision System Corporation Holdings Incorporated. And they asked de Blasio to sign an order to show cause for the sheriff to seize my 4 shares in CS. To seize my 4 shares in CSC Holdings Incorporated. But I have no shares in CSC Holdings Incorporated. So it has a fatal defect in it. And nothing has come of it, nothing will. It's amazing how, in broad daylight, they can make such fools of themselves. I am talking about Charles F. Dolan, James L. Dolan, Robert Lemley, William Bell, the Board of Directors of Cablevision, Charles Dolan's court jester, Charles Former. I'm talking about these sleazes and the fools that they will make of themselves in broad daylight. Cablevision does not own public access. We do. It was given to us by Congress. It was given to you, the public, by Congress. Your public's right to hear and know, and our right to tell you. So Cablevision does not own public access. We do. And this is this crooked judge, John P. de Blasi, and we have to keep working to get rid of him. This is the judge who, instead of being in court for 31 mornings, was at the Connecticut School of Broadcasting taking a course in how to be a TV host. And here he is caught coming out of the Connecticut School of Broadcasting. De Blasi spends time in TV class, not in court. Gannett caught him cheating, and Glendora has caught him cheating several times and exposed it to you for years. John P. de Blasi, Supreme Court, so-called, County of Westchester, State of New York. Get rid of him. About funerals. You people, do you want to spend $7,500 on a funeral? Well, you can. Funeral directors will get it up to that if they can. Now, if you do want to do it, that's fine. If you don't want to do it, though, and if you don't want life savings to go that way, then you must right now sit down and call up the funeral directors, get the prices, choose the funeral director you want, write it on a piece of paper, and hand it to your loved ones. Because when you die, your loved ones are going to be in great grief. And they're going to say, oh, well, that doesn't show respect if we don't buy that for the funeral. So I have it all set, and then that confusion and uncertainty and ripoff will not agonize the ones you leave who are so unhappy about your passing. So just do that. It's a simple thing. Here's shareholder information. Here's my dividend from Texaco, and it is 90 cents with the price of gasoline up to $1, and last week it was $1.60. The week before it was down pretty well, $1.49, $1.50. I don't know why our government doesn't protect us from this outrageous monopoly of gasoline prices. Anyway, it says that the Texaco annual meeting will not be held in April as it always has been, and Glendora takes full credit for that. Okay? Because remember how Glendora exposed Peter I. Bajur at the last annual meeting, and he is out. He's a goner. And he got what he deserved. Too bad I don't have time to read you these legal papers. But remember, one good thing that happened last week was this a matter of justice. These people are petitioning Congress to get rid of these crooks in the courts, in the federal courts. And then we got to get rid of the crooks in the state courts and the crooks in the municipal courts. I will tell you the springtime joke. It's 3:23 a.m. on April 17th, and I have to use a short form for videotaping because there just isn't time to give you the full reports that you should have. Springtime joke. It's a bright spring day, the sun is shining, and a worm comes out of the ground, and 3 inches away he sees another worm. And he says to her, "You're beautiful, you're lovely, I love you, I want to marry you." And she said, "Oh, stop it, I'm your other end."
Facto clause of the Constitution. You cannot make things ex post facto. You cannot make laws that affect what people did beforehand. There's an exception here, okay? And this is why our tax code is so unjust, is because you can go along, you can have the best CPAs in the world, and there are actual cases like this, and you conducted your affairs according to the laws that were on the books for 10 years. Congress comes along and passes a statute that increases your tax liability, all right? Because there is no ex post facto clause for civil actions at the federal level. Then what can happen, this is basically what happened on this case with the Torture Victim Protection Act, what happens then is, now since Congress has passed this new law, now the Justice Department is going to come after you, the IRS is going to come after you, because under this new law, instead of you paying 20% taxes, now you're supposed to pay 30%, and since ex post facto does not apply in a civil case, which includes tax collection, now you owe all the extra 10% for all those years, plus you can owe the interest and penalties also, all right? And the reason this nonsense got started is that back in the early days of the Republic, before 1800, Congress was getting ready to pass the bankruptcy laws, because what's not too well known today, you'll see this in Bowden's Government by Judiciary, is that we actually had debtors' prisons into the early 19th century, just like England did. If you could not pay what you owed, they would lock you up. And sometimes they'd lock your wife and kids up there with you. And so in order to stop this nonsense, Congress was investigating the bankruptcy laws. Now at the time, the United States Supreme Court judges, there were only 5 of them, the beginning days of the Republic, and then they started increasing the numbers, and then Franklin Roosevelt tried to pack the court, which, as far as I'm concerned, he should have, except he should have packed it with gunpowder. What happened next is that one of the Supreme Court judges was on the lam. In other words, as soon as they caught this guy, they were going to put him in debtor's prison. So his four buddies on the United States Supreme Court said, well, when Congress passes this bankruptcy law to protect debtors, if we go with the ex post facto clause of the Constitution, he will have no protection under these bankruptcy laws, so therefore we're going to hold that yes, ex post facto holds for criminal cases, but it doesn't hold for civil cases. So because these four dirtbags were trying to protect their buddy, we have had a tax code that every time Congress changes it for the worst, literally breaks people right and left, all because of one deadbeat federal judge prior to 1800. That's the way that worked. And so what we did here is we showed that, number one, the Supreme Court didn't have the authority to do that, and number two, since these were criminal acts these people were being accused of, ex post facto would apply. There's a good quote from Bowden. Let me show you how good Bowden is. Go here to page 52. It is one of the essential weaknesses of the government by judiciary that, as in all theocratic governments, based upon the sole power to expound a sacred text, its priests cannot afford to admit error without undermining the power of the priesthood and upsetting the form of government in which they are the ruling caste. Error must therefore be perpetuated no matter what the consequences. For to those who believe in that form of government is of much more importance than the alleged sacred text upon the exposition which it is supposed to be based. There's pages and site numbers. And then there's a sixth cause of action, due process, a seventh cause of action, obstruction of justice. Then we go into the RICO conspiracy, the legal claims, which gets kind of voluminous. This is something that if you're in the Ninth Circuit or if you have a situation in which you actually want to be able to take conflicting case law and make these clowns go one way or the other. Problem is that most people, since they are not aware of the fact, now the Eighth Circuit does this also. If you're in Arkansas, Missouri, Iowa, the Dakotas, or Nebraska, the Eighth Circuit also gives itself the right to take either line of case law they want in order to adjudicate a decision. And if you want to put their feet to the fire, this is how you do it on that particular issue. Remember with Tapia Ortiz, the issue was failure to address the issues raised. With the Ninth Circuit, the issue is contradictory case law. And if you think the judges are not the ones who actually make our laws, you better read some of these published opinions. Now, the next thing, remember what I just said about the sacred text? Let me give you a case. This is only part of a case here. I thought I had another player who was going to rock and roll with this thing in the Ninth Circus, but I guess he decided not to. In this particular set of facts here, remember what I said about theocratic government? Remember what I said when this seminar began? Ladies and gentlemen, the people you're up against aren't just your enemies, they're God's enemies. Let me prove it to you, okay? And it sounds like I'm going to be going a little far afield here, but just bear with me and you'll see what I'm talking about, okay? Stoicism. Stoicism, school of philosophy in Athens and ancient Greece, was founded about 300 BC by Zeno of Citium. Stoicism was later introduced to the Romans by Panatius of Rhodes. Outstanding Roman Stoics included Marcus Tullius Cicero, Cato the Younger, gives Epictetus, Marcus Aurelius. Stoicism, now this is the clue here, Stoicism was the most influential philosophy in the Roman Empire prior to the rise of Christianity. Okay, now philosophy and religion are interchangeable terms. Here's the definition for religion. As used in constitutional provisions of First Amendment forbidding the establishment of religion, the term means a particular system of faith and worship recognized and practiced by a particular church, sect, or denomination. Religion, a particular system of faith and worship. Philosophy, a particular system of ideas relating to the general scheme of the universe. Okay? Now here's a quote from 1892. This is a Christian nation. Okay? The Christianity is actually in our Constitution. Every Sunday school student knows the fourth commandment, 1961 Supreme Court dissent. And you'll see that in the Constitution, because when they count forward, it shows you that there's one, you can count forward one day on a Sunday, okay? 6 days shalt thou labor and do work, and so forth, the King James, okay? Here's where the Constitution itself recognizes the Sabbath. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Article 1, Section 7. Well, at least we were supposed to be a Christian nation until the now infamous decision in Roe versus Wade. Now, let me prove to you that Stoicism is a religion. In one of the most moving hymns of antiquity, Cleanthes prays to Zeus, "Grant that I may find the judgment in which you trust and by which you steer all things with justice." There's the citation. At any rate, the Stoic God is not absolute. Unlike the Jewish God, he does not bring forth the world by fiat. Now, let's go to Roe versus Wade. Ancient religion did not bar abortion. The ancient religion promulgated in the Old Testament did. Whoso sheddeth man's blood, by man his blood be shed, for in the image of God made he man. And then there's the rest of the biblical citations here, okay? And you get down to the last biblical citation, "Let the day perish wherein I was born, and the night in which it was said there was a man-child conceived." That is, the embryo was considered a man from the moment of conception. Now, here's some quotes from Roe versus Wade. I'm going to give you the first one on this page. Most Greek thinkers, on the other hand, commended abortion, at least prior to viability. For the Pythagoreans, however, it was a matter of dogma. For them, the embryo was animate from the moment of conception, and abortion meant destruction of a living being. And then they tell you, of course, here in the next line, the emerging teachings of Christianity were in agreement with the Pythagorean ethic. I'll contradict myself here. I'm going to have to give you this. There has always been strong support for the view that life does not begin until live birth. That was the belief of the Stoics, okay? Now, at this point, what happened was the United States Supreme Court decided to impose Stoicism as the national religion of the United States, okay? And there's a couple of interesting videos on this that I watched. Both these women in Roe versus Wade and Doe versus Bolton, neither one of them wanted an abortion. Their attorneys picked it up and ran with it. The whole thing was a fraud upon the court, and when you have a fraud upon the court, that invalidates the decision. In other words, Roe versus Wade and Doe versus Bolton were both put together by attorneys practicing fraud upon the court. This explains next what the fraud upon the court is. Okay? It shows you a history of, for example, it shows you the school district of Abington Township versus Shemp. Shows you how they got the Bible out and prayer out of the public schools. And it shows you, there's another case here that where Roe is showing you how what the Supreme Court did is they didn't build on the Constitution, they built on their own prior decisions for this nonsense. And Christians understood Stoicism by another name. What you'll find if you go back in your encyclopedia sets and your history books and that sort of thing, is that Stoicism, these Stoics were followers of Zeus. In the Roman, he was known as Jupiter Olympus. And in the Hebrew, in your Bible, he was known as Baal. In other words, Supreme Court, June 22nd, 1973, installed Baal worship as the official religion of the United States. Unfortunately, nobody has ever called them to task for this. And the final thing I want to give you here on this particular case, this is from a case from the a quotation of the 3rd century BC. The arrow shot by the archer may or may not kill a single person, but stratagems devised by a wise man can kill even babes in the womb. And unfortunately, this particular case here, this is only a small part of the case. There were two facets to it. One was the, discombobulated in here with break. One was the judicial anarchy. The other was the installation of Baal worship. That's it for me for today. I will see you here. Hopefully you'll be bright-eyed and bushy-tailed in the morning. We're going to take a break, and then Peter is going to show you what's available over here, what you need, and so forth and so on. Because like I said, I know we have a lot of neophytes here. At the very least, every single one of you who does not know how to shepherdize, who doesn't know how to look up case citations, you need the lawsuit cookbook, and none of the other stuff's going to hurt you either.
We are the Erwin Rommel School of Law, and our mailing locator is P.O. Box 211 in Atwater, Minnesota. The Babylonian commune number 56209-0211. Our telephone is 320-857-2400. Our fax is 2401. And our email, our website on the net, http://members.aol.com/RommelLaw. And we're going to have a tour of the bookstore, and then we're going to send you off to dinner. We'll be right back. Thanks a lot. And welcome back. This is our crass, naked commercial message. And it's nice folks like you in the United States. I have a lot to cover, so this is going to kind of be the Evelyn Wood version of Erwin Rommel's bookstore. The flagship of the fleet is the Bible the Puritans held at Plymouth Rock in 1620. This is the 1599 Geneva Bible. This Bible is laid out like a federal appellate brief. Actually, it's backwards. The first paragraph that you read in the book of Genesis says, "the argument." And in your course materials, you'll see in table of contents in appellate briefs, "the argument." King James loathed this Bible so bad that he made its ownership, production, or distribution a felony. In 1607, he released the Bishop's Bible. It failed to win popular support. In 1611, he released the authorized King James perversion. We have for free for you folks the King James written instructions to his translators. Number 6 is no marginal notes. The margin notes in this Bible have literally gotten purchasers of it thrown out of incorporated churches in the United States. 71% of your Bible applies to civil government bureaucrats only. Only 29% of the laws in your Bible, regardless of edition, apply to your specific individual conduct. The new kid on the block for us is the 1841 English Hexapla. This comes in 2 volumes. This is volume 1. This is a 160-page dissertation on the creation of the Bible in the English language, printed in 1800, followed by an 1805 edition of the Greek Textus Receptus with Wycliffe's 1382 New Testament, Tyndale's 1534, Cranmer's 1539, the Geneva's 1557 New Testament, the Anglo-Reims, or the Roman Catholics' Reims New Testament, and the King James of 1611. The New Testaments are laid out in parallel columns so that you can compare the translations from Wycliffe through the King James, and the Greek original is in the upper third of the page. The Geneva Bible and the Hexapla Bible both are $129 in our catalog. For our seminar attendees, they are $100. We open the seminar with the Jerusalem Bible. If you're interested in the Bible as law as opposed to religious nonsense, this is a wonderful tool. It is a now out-of-print Catholic Bible, translated from the French. It uses the correct sacred names. It makes the turgid language of the King James and the Geneva, and even the Farrar Fenton Bible, which we also have in our catalog. It just opens the New Testament into a very easily accessible circumstance. Where the New Testament is poetry, the Jerusalem Bible blocks poetry And where the text is prose, the Jerusalem Bible blocks prose. So it's a wonderful tool and comes very highly recommended. Two of the many suppressed books in the Scripture are the book of Jasher and the book of Enoch. Although both of these translations are suspect by certain scholars, you get in the book of Jasher for about 60 minutes and you'll figure out very easily why the government-controlled churches removed it from the Old Testament. This is hardball, bare knuckles, in your face, the result of what happens when you start obeying rather than believing. The Jasher is 20 bucks. Enoch is 12. The two together. Fabulous stuff relating the Bible to you as a legal document as opposed to a religious document. And it closes with a reprint of Bill Strittmatter's explanation of the Bible as a civil government constitution, Christian constitution and public policy for the kingdom of heaven on earth. And it really demonstrates to you very quickly the difference between law and religion. The guts of the Bible Law Index are your responsibilities toward your fellow man, your responsibilities towards Yahweh, and it lays out the Old Testament and New Testament and just breaks it down as a law book. The Bible Law Index is 10 bucks. This is rescued from the memory hole in the United States history. This is Chaplains and Clergy of the American Revolution. This was printed in 1856. It was compiled by J.T. Headley. You will read the sermons preached during the American War of Independence. The American War of Independence was organized and operated out of the pulpits of the American colonies' churches. And these whorehouse operators out here today with their 501c3 IRS tax-exempt corporate status ain't never heard preaching like this, not ever. Pastor Muhlenberg opened a sermon in Pennsylvania with Romans 13, be subservient to the higher powers, they're ordained of God. 80 minutes later, he took off his clerical vestments, and underneath, he was wearing his Pennsylvania regular militia major's uniform. He stood the men of the congregation up, he marched them out into the town square, he signed them up for General Washington's army. When Lord Cornwallis surrendered to George Washington, General Muhlenberg was a staff officer present at the surrender. And you just haven't dealt with preaching like this until you, pick this book up. We have a number of serious and dangerous and grim books on the table that show you what happens in your interfacing with our electronic Babylon. This is Life Without Usury. The reason the Arabs are the bad guys on TV today is because they have reintroduced Sharia banking. And Sharia banking is profit sharing only. There is no usury or interest on loans. There is no confiscation of collateral assets pledged against a loan of nothing if the lender defaults. And that's why every time you turn on the electric toilet, you're dealing with the Arabs as the bad guys. Life Without Usury is 10. This seminar is dedicated to my father, who passed away about 3 weeks ago. This is his book, Unhealthy Food, Unhealthy People. My father died at age 90. He was a biochemist. For you ladies in the audience, the most radical and dangerous appliance in your home is your refrigerator. The problem in the United States is 80% of the food sold to you and me is stale by definition. And it is the byproducts of the ingestion of stale food that puts plaque into your arteries and initiates the cancer cells production in your body. Unhealthy food and unhealthy people is 15 bucks. Of the Wheat, this is 2 books in one. Past the Yellow Divider is her second book, The Upper Crust. This is bread making A to Z, the way your great-great-great-grandmother did it. And the secret to bread making is you must grind your own grain. If you are not grinding your own grain, you are creating glue. You might as well eat the box that the stuff came in your kitchen. If you grind your own grain and you soak the dough for 7 hours, which is completely explained in 3 different sections in this book, you turn glue into food. You'll notice the scripture says, "Give us this day our daily bread." And I submit to you that there is a biochemical reason for those exact words coming to us in English. To that, the bleaching of flour, North Dakota Agricultural College Government Agricultural Experiment Station, bulletin number 72, November 1906. with rules in the several states track the federal rules. I neglected to show you one of our best tools. In your information pack, you will find a page that says Training Videos You Can Use. And the training videos we have is one of the few products produced out of house. There is a notorious pro se litigant in Denver, Colorado. His name's Barry Lynn from the House of Smith. And he has produced with a TV outfit in Denver these two videos. The first one is Pro Se Legal Research. And this is an 85-minute tour of Denver, Colorado's largest law library. And it was professionally filmed by a TV studio. The second one is Winning with Court Rules. If I title it Winning with Civil Rules, this is a 2-hour tour of the rules of civil procedure by a licensed paralegal in Colorado. And what this tape will do for you is when they throw all these procedural gimmicks at you, you will know how to oppose them, and you'll also know how to do some of them on your own. With the civil rules video, we include 3.5 hours of our friend and associate Peggy Dadick from West Palm Beach, Florida. We had an Erwin Rommel seminar down in West Palm Beach, and this is Peggy's review of the civil rules and all of the ugly and dirty and nasty tricks that they will play on you. So I did want to get those on camera for the benefit of the tape audience. The two videos are $100. And as Sun Tzu said, all battles are won in the preparation. And these tools will take you a long way to being adequately prepared. And now we're back on deck with the Field Marshal himself, Michael H. Brown. Thank you.
All right, normally what I do on Sunday morning is I go back over and bring up all the things I should have told you the day before. And then, of course, there's a couple of refreshers. The right side of this board, we're going to get right back into the meat of this, but there are some things that we do need to go over. If you run into a problem, because some of you are going to be doing your own 372s, and if you run into the kind of crap that you run into in the Sixth Circuit with Boyce Martin and the rest of these idiots, what you do is you ask your congressman to file it for you. And one of two things will happen. Either somebody on his staff is going to write the offending party a letter and say, you know, what is this? You know, where did you, you want to explain yourself? Well, the whole idea here is to make life miserable for these people, the mosquito theory of judicial discipline. And if they start beginning to understand that it's easier just to file them like they should have done in the first place and give them docket numbers than to play all these cute games to try to make themselves look good to Congress, because that's all they're doing. That's one thing that can happen. The other thing that happens is you'll get some congressional staffer, because when you write to a congressman, you don't actually get the congressman. You get some jerk that works in the office normally, and some of them are jerks and some of them aren't. Well, if you get a jerk, what he'll tell you is to get a lawyer, and then he'll start sniveling about separation of powers. Well, that's when you write him back. It's when you make the staffer's life miserable and say, look, in the first place, no lawyer has the nerve to do this. There are about 2,500 of these 372s, or there were 2,500 of them filed every year until we went on the offensive 2 years ago here. And out of that 2,500, 2 of them were filed by attorneys. Of course, now it numbers in the tens of thousands. It's the whole idea of just isolate and destroy. In other words, to destroy one federal judge's career at a time, then the others, they hear, they fear, and they straighten up. Separation of powers, we went over that yesterday. You just explained to the Congress, congressional staffer that separation of powers appears nowhere in the Constitution, appears nowhere in the statute law, and here's the case site that you can look up. All right, in other words, this guy's going to understand real quick, uh-oh, he's dealing with somebody. Now, a little stunt that I thought about pulling, I just haven't got around to it yet, is when you get this runaround from somebody on a congressman's staff, find out who the head of the congressman's office is, and sue him under Bivens and the First Amendment because he's denying me the right to petition the government for redress of grievances. And when this clown sees his name on a docket number, he realizes all the work he's got to go through. Yeah, he may get something done. Just haven't had to do it yet so far. Now, I want to congratulate you people. I'm proud of you people because when I called for volunteers yesterday for 372s, of all the seminars I've given, and I've given dozens, this group right here has the highest percentage of volunteers I have ever seen. Normally I only get about a third of the people. You people seem to be in a tremendous majority, okay? Has anybody done their case analysis that they want me to look at? Show of hands. 1, 2, okay. And what I want you to do at the end of this set is come up here 50 words or less, put it on the table, let me take a look at it, I'll address it in the following hour. Now, I gave all of you a homework assignment last night. How many of you actually did it? 1, 2, 3. Okay. Huh. Yeah, he forgot what it was. One of my star trainees. You never knew, okay? You didn't even know. Warriors, I'll tell you what, you people have gonads, but your attention span leaves a lot to be desired, okay? Now, again, let me remind you about Diane and the computer searches. If you have a particular question or anything like that, during the break, you come up to her and you say, I got a particular question, I need a particular statute looked up, I have a particular case I want taken care of, and then we'll go from there. Thurston, real quick.
Okay, you were talking about the congressman, and usually you run into the guy who's some college dropout who's working for the congressman. I do this all the time. So we find this guy working for the congressman, he doesn't know anything. Most of the time they don't read anything. So we're working to make our letters as short as possible and address the issue as quickly as possible within 1 page. 1 page has always got to be your target. If you can get a 1-page brief, they can't rewrite it. If you send them a 1-page letter, they won't avoid opening it up to do the work. Now, once you get resistance from that idiot, you move to the state supervisor. There's a supervisor over any and all offices of the senator or congressman.
I'm talking about a federal congressman.
That's what I'm talking about.
Okay. There's a state supervisor?
There's a state supervisor.
Okay.
Someone who supervises all of their offices within the state, not the offices in D.C.
Oh, I got you. Okay.
And then from there, once you pass by that person, who's usually a lawyer and sometimes knows what's going on and can sometimes help you, then you move to the chief of staff if that person is still resistant. From the chief of staff, you then go and try to get that chief of staff to take your issue into the congressman's office where he will give a direct answer. What I'm working with TaxGate and NITE is to get the congressman to give me a written position as to why he doesn't support the due process rights of his constituency. And then I post his picture up at denialofdueprocess.com, where if you go there now, you will see a nice, lovely picture of Senator Herbert Cole of Wisconsin. And I intend to put every single congressman and senator's picture there who shows me that he's not interested in standing up for the due process rights of his constituency. The good guys get to go up at ruleoflaw.com. This 372 effort that I've been talking with you about, want to support you with, I want to put in at denialofdueprocess.com. And, of course, start listing the federal judges and the congressmen and the senators and their chiefs of staff who are resistant, and show the people these are the ones who are resisting you. It's not a hit list. It's not anything like that other list. This is about knowing who the players are, who's in the way. This is who you got to vote out. These are the people you got to apply pressure to. And when you talk about suing, you don't sue that little guy who's doing his job, because his job is to deflect from the congressman, deflect from the chief of staff, deflect from the state supervisor, and to avoid that 4-letter word that begins with a W and it has a K on the end with an O and R in the middle. So you push through to the top, exhaust your process with those people. Then, if you want to do the RICO with someone, who are you suing? The congressman, the senator, or all 3 in your state at once.
Okay, excellent. Thank you. Now, this next is a website. This is the National Anti-Lawyer Political Party, www.antilawyer.org. I don't need to tell you a whole lot about it because I'm the national director, so you can have a pretty good idea where we're coming from, okay? In fact, we have a fellow named Joe Keller in St. Louis right now who is rapidly moving towards getting us on the ballot in Missouri. The whole idea of this is anybody goes down a ballot. I don't know if you're aware of how most people vote. They're so lazy, they just look at the first name. But if you have Republican, Democrat, and anti-lawyer, guess how many votes anti-lawyer is going to get, even if they don't know who in the dickens you are, okay? Now, this particular tie I'm wearing here, my wife's got some for sale over here, and the reason I wear this particular tie at all these gatherings is because the people I've trained, once they have graduated from the Erwin Rommel School, are entitled to wear the plaid of the Clan MacGregor. I don't care if you're Chinese, okay? Because what we're trying to do is, through the courtrooms of the United States, when somebody comes in wearing one of these, at some point, some judge is going to look at it and say, oh crap, it's one of these Erwin Rommel guys, okay? A little aside here, one of the reasons that a lot of our stuff works is not because we study just law books, but if you get books on military history and business, you'll find that the people that you read about or the people who write the books on business have original ideas. Most lawyers have no original ideas. They're like the killaloo bird, which flies backwards and doesn't look where it's going, it looks where it's been, okay? And if you want to learn how to think differently, these are two of the best type of books you can get. For example, one of the things you learn out of military history is what's called a force multiplier. For example, on a 372, if you launch one, well, it's not going to really go anywhere. It's kind of like a muzzle-loading musket. You load it, fire it, the guy closes with you, and you're toast. On the other hand, the difference between one person with a 372 and a whole bunch of us, it's called a force multiplier. Again, it's the difference between the muzzle loader and the machine gun. The machine gun is a force multiplier. You need less troops to use a machine gun and do the same amount of damage than you do with a whole series of muskets. Now, I want to get into some of these other cases here. And these citations, the reason I have them up here is because I do not have them in your course materials, because normally when I give one of these seminars, a lot of the things that I will bring up, I just discovered in 2 days or 2 weeks before the seminar myself. A lot of these things, in fact, I'm going to show you one that we just came up with in the last 30 days that puts a whole new spin when you get shafted by an appellate court. And this one here, this Green versus Seymour, the principle here, it's 59 Fed 3rd 1073, go to page 1078, it's a 10th Circuit case out of 1995. What it tells you is a district court cannot review and reverse a decision of a court of appeals that is challenged in a civil rights suit. And this is normally why when you do a RICO against a circuit court of appeals, no district court's going to touch it. Not only are those his buddies, but there's precedent to support that a lower court cannot overrule a higher court. But if you get a 3-judge panel from another circuit, they're on an equal footing, they can give you some air. Now, the next one here, this case, Olson versus Hart, 965 Fed 2nd 940, go to page 943. It's also a 10th Circuit case from 92. It tells you that arbitrary and capricious actions violate due process. In other words, if an administrative agency or court or anything like that is going by whim and caprice, that violates due process. I want you to look at a comparison here. This first case, they're giving you federal supplement sites. Federal supplement cases actually have no value as precedent. They're not what you call controlling case law. In fact, you'll even see cases that say they have no value as precedent, but they do act as a guide. The next one here has Supreme Court sites, and so the Supreme Court is supposed to issue rulings that the lower courts follow, which of course is not normally what they do. Lower courts, if it's a good Supreme Court decision, they'll water it down. If it's a bad Supreme Court decision, they'll enforce it unmercifully. Now, this next citation here, this is Agency Holding Corporation versus Malley Duff. It's 107 Supreme Court 2759. It's 1987. This is the case that tells you the RICO statute of limitations is 4 years. The next one here is the this particular case here, let's see, where are we? 155 Fed 3rd 500, comma 505, 506. It's a Fourth Circuit case. That's where we are right now. The Carolinas, the Virginias, and Maryland from 1998. The name of the case is Anderson versus Advancement, etc. of American Indians. And there's a real thorough discussion of RICO. And the reason you want to read this particular case and a real thorough discussion of RICO, because when you get around to filing a RICO against the Fourth Circuit itself, the judges in it, you don't want to make any mistakes. The next case here, this is a Fed sub case. And what it tells you, and this is actually a legitimate principle, is that your RICO claim must fail if the substantive claims are themselves deficient. This is Stewart versus Associates Consumer Discount Company, 1 Fed sub 2nd 469, comma 475, from the Eastern District of Pennsylvania in 1998. And what this is basically telling you, if you'll go back to Title 18, Section 1961, if you've charged somebody, say, with 3 counts of obstruction of justice, and the counts actually don't arise to the level of obstruction of justice, then the RICO complaint itself is toast. Now, this other case here, that's this 114 Supreme Court 996 from 1994, this is FDIC versus Meyer, and what it tells you is that constitutional claims are not cognizable on a Federal Tort Claims Act, and discretionary acts are not reviewable either. Federal tort claims, I'm going to show you how that works when we get through the RICO sections, but what you're going to find in many cases, as you found out in the Tapia case, is that quite often you can use something in place of a Bivens action and you'll get further with it because, like I also pointed out at the beginning of this seminar, the Supreme Court and even the lower courts rule upside down. In other words, they will take the statute over the Constitution. If the statute does not give them the authority to litigate a constitutional issue, the courts won't deal with it, which is actually bass-ackwards of the way it's supposed to be. Now, this statute down here, this is the Tucker Act. Normally, what you're going to find is that anything that you can bring under a Bivens action, you can bring either under the Tucker Act, and the statute is Title 28, United States Code, Section 1491, or you can bring it under the Federal Tort Claims Act. And if you get a chance, that's always the best way to do things. Now, that pretty well takes care of the house cleaning that I needed to do this morning and the introduction. Now we're going to go to the RICO section for the 10th Circuit. How many people here are from the 10th Circuit? Show of hands. 1. Okay. We're going to go through it anyway. Okay. And the reason is because this is judicial activism. This is a perfect example. This case is probably the best example you will ever see. It hasn't been filed yet of a RICO and a petition for declaratory and injunctive relief to show you what this case illustrates is how to take a Circuit Court of Appeals case that you know is absolute crap and turn it upside down and smack all the jerks who are responsible. Let's go through the usual business. You're familiar with the jurisdiction. Of course, here's all the defendants listed. Then here's the facts. This guy got banged on a money laundering case. And fact is, he didn't launder anything. What actually happened is that he had set up a bank in on the Indian reservation. What he was going to do was do an offshore banking type operation inside the United States by parking it on an Indian reservation. And so the feds decided that, oh, what this guy's doing is money laundering. Well, money laundering means you're trying to conceal something, and that's not what he was doing. I mean, there's a perfectly open trail on it, but what's happened is that there has been such a frenzy on these forfeitures that the prosecutors have taken right after the federal judges in bending and twisting the meaning of words and statutes and everything else just to arrive at a predetermined goal. If you've got $1 million, trust me on this one, as soon as the feds find out about it, they're going to figure out some way, by the misuse of language, by the twisting of statutes, by abuse of process, by misuse of legal procedure, they're going to find out some way to take it away from you. Now, This fella here had several issues. He had the grand jury issue, which I'm not going to go over with you here because we're going to run out of time if we do. I mean, I could probably give you a 2-day seminar just on the grand jury. You'll get an idea. Starting on page 14, it shows you what was wrong with the indictment. But now we get down to page 15, okay?